Mr. Craig.
Good morning, my lords, my lady. I'm Craig Ralph, and together with my learned friend, Miss Bedford, I appear on behalf of the appellant, Oakwood Solicitors. And my learned friend, Miss McGungle, appears on behalf of the respondent, Mr. Menzies. Brief housekeeping, if I can. The court ought to have three bundles: a core bundle, a supplemental bundle, and then an authorities bundle. I understand that yesterday afternoon there was a further authority emailed to the court. That was the matter in the Court of Appeal in Harrison and Chew. Hopefully that's found its way to you. It's not an authority of which I'm going to trouble you, but it may be something that my learned friend...
You may have to speak up a bit,
Sorry,
Mr. Craig, if we're going to hear you comfortably.
Ah, well then I shall project.
Thank you.
I shall put on my best theatrical voice.
Mr. Ralph.
It's Ralph.
Oh yes, sorry.
My lord.
Forgive me.
Many people
I also was
confused
confused by the appearance of Miss Bedford, which I now have written down.
Ah, there's no harm done at all, my lord. So there should be three bundles. The bundles are differently numbered depending upon whether one uses them electronically or whether you use them in their internal numbering. I'm going to refer to the internal numbering if I can, but that may be somewhat confusing if you're searching electronically.
Can you give us the electronic numbering on
Yes, I can give both.
That would be very helpful.
There's no trouble, my lady.
Thank you.
My submissions are going to be via my skeleton argument. I shall refer to those, and I'm going to split them down effectively into 5 headings. I'm going to speak ostensibly to the issues and what is not an issue. The court will have already noted there's no respondent's notice in this case. I'm then going to deal with the facts as were found at first instance, and then the decision of Bourne J on the first appeal. And then I'll deal very briefly with the authorities, and I say briefly for reasons that I will come on to when I get to the main thrust of my submissions. And then I'll make the rounding up submission as to why I say that the judgment of Bourne J ought to be set aside for the reasons that in effect are already articulated in my skeleton argument in paragraph 4.
But you're going to tell us why the 19th century authorities don't prevent us doing that, aren't you?
I am. Shall I start there?
Yes, it'd be very helpful.
Whilst starting with the words I was going to speak to my skeleton, I'll ski off-piste if I can, and actually come to the nub of this.
There's quite a lot of off-piste skiing in this court, Mr. Ralph.
Well, hopefully I'll be in good company then, my lord. I say the 19th century authorities don't help you and don't assist because we are living in a different world. I say that if one looks at this case through the lens of the authorities, then you fall into primary error. You fall into primary error because those cases speak to a different age. They speak to a pre-digital age. They speak to a pre-conditional fee agreement regulations age. And they speak to a pre-LASPO age. All the authorities have a commonality. They are either where cases have a bill has been delivered, or in cases where a bill hasn't been delivered. What they all have in common is that there is some argument at the end in relation to whether or not there has been settlement of account. But that is a manifestation of the bare retainer, which is the concept referred to repeatedly in the authorities.
I don't think I really understand that.
I've understood it.
You say that settlement of account is a manifestation of the bare retainer.
And the time in history that it was undertaken. But in Pracy, under a bare retainer, ordinarily, we don't know the facts from the authorities as to what in fact went on, but the reference is simply to a bare retainer. But one would have expected historically that you would have gone to your attorney, your solicitor, and instructed them to do a piece of work. And that retainer would have then sustained through to the end of that piece of work. And at the end of that piece of work, there would have been a reckoning between the solicitor and the client, an agreement and payment over. And one assumes thereafter there'd have been the delivery of a statute bill to make whole that which had gone before. But the modern, and that would have been the negotiation. That's how the negotiation leading to the fee would have been. But in the modern world, post the digitisation and post the 90s when we became digital.
I mean, Section 70 applies to contentious and non-contentious business.
Yes.
Yeah, I mean, I'm right about it's a question.
Yes.
Yes.
And the notion, so you can have a bear retainer in the sense that it is do some work and we'll do a reckoning at the end, or it could be a bear retainer where you make a payment on account and there's an hourly rate accounting, but there's an accounting at the end. Whereas with a conditional fee agreement in the digital age, the same steps are taken in that you have negotiation. You have a statement of what it's going to cost, and you have a final reckoning in a bill, but it changes position.
What changes position?
The process. I'll just go back so that I'm making myself clear on this. Under the authorities, the linear is there's a retainer, and then at the end, there's negotiations to the fee, and then the final reckoning, the statement of account and the settlement of account. But with a conditional fee agreement work, you have to do it at the beginning.
So is it just a timing issue?
It's a timing issue.
Right.
You have to do it at the beginning, because if you don't reduce it to writing, then you fall foul of Section 58 of the Costs Legal Services Act, and your CFA
So you've got
comes
to take
under.
this more slowly, okay?
My apologies.
You know, don't assume that we know as much about all this on a day-to-day basis as you do. Now, you have to do, I mean, you keep on talking about a reckoning, which I find an unhelpful word. You have to put in writing the terms of the agreement at the beginning because of Section 58 of the...
Courts and Legal Services Act, my lord.
Which year?
1980.
Right. Yep.
And just to complete that submission, what Section 58 mandates is that if you have a conditional fee agreement and you don't reduce it to writing, then it is unenforceable as a retainer.
But so what about a case where you don't have a conditional fee agreement? Do you say that you still, that timing still works so that...
The timing still works, and the reason for that, my lady, is this, that the conditional fee agreement regulations in Section 58 of the conditional fee agreements and the background that drives conditional fee agreements, and also to some degree damages-based agreements, they're all part of a legislative or control framework which has a degree of modernity to it. By way of example, even if you were not utilising a conditional fee agreement retainer as the basis of your relationship with your client, in the modern world, much litigation is done, if I can use the phrase, at arm's length. Clients are signed up who are not in close proximity to the solicitors anymore. It's done online, it's done by email, it's done by telephone and sending paperwork.
But are there requirements for an agreement in writing?
What those trigger, what distance selling triggers, is statutory requirements to comply with certain regulations. So, for instance, there's the distance selling regulations. They're all consumer protections.
But we are concerned with what amounts to payment, what is paid in Section 70.
Correct.
And as my Lord the Master of the Rolls has pointed out, Section 70 applies both to contentious and to non-contentious.
Yes.
And many of the cases to which we've been referred are solicitors who take money out of the proceeds of sale of shares or property or whatever it is. So whatever the word pay means, it's got to be thought the same for both contentious and non-contentious business. Or do you say it has a different meaning depending on the type of retainer?
No, I don't think it ought to. It ought to have a consistent meaning.
Yeah.
And that consistent meaning could be put in many different ways, but ultimately it means that you move money from one place to the other. That's payment. It goes from one repository to another repository. Now, whether it flows directly from the client's direct pocket into the solicitor's funds, or whether it is the solicitor moving it from the solicitor's client account into office account, payment is a mechanism. And that ultimately would be the payment of the bill.
Does it require the client's agreement,
I say it does. There has to be an agreement. But what my overarching submission is that that agreement does not have to occur at the point in time of the delivery of the statute bill. In other words, it doesn't have to be at the end of the litigation. Or the non-contentious business.
So you say, if the client agrees to a 48-page CFA, which says on page 46 at line 6, you agree with me that when I get damages, which at this stage to the client is sort of a pipe dream anyway, when I get damages and costs in my account, I can deduct all my fees, which may be massive, because you may remember what I said in Belsner and Karadzic about the way charging goes. I can deduct my fees. That's the agreement, and there's no need for any subsequent agreement.
Yes, I say that. Well, can I put a nuance on that, my lord?
Well, I think it's the nuance that is what this case is about.
There may well be a distinction to be drawn with those cases, whereas here there's a cap put on it. The 25% of damages cap, it will never exceed. So there's a cap. So what the client knows is that at the end of the litigation, if they're successful, they will receive 75% of their damages.
Absolutely, less your fees, which may be huge.
No,
Not if there's a cap.
because the cap, which is in this case, guarantees them.
The cap is only on the success fee.
No, the cap's also on this case to 25% of damages.
Oh, I see.
It's the same as was in Herbert and H.H. Law.
Yes, yes.
It's the same principle. And what that does then gives a certain degree of certainty to a lay client.
So the cap is 25% of damages for everything.
Indeed, there are two caps operating, aren't there? There's the statutory cap, which is in relation to the success fee. That's
Yes.
imposed by statutory instrument. And then there's the cap overall, which is contractual, which is in this case, the contractual cap is 25% of damages. Will never exceed that. That's what's clearly written in the CFA. So to pick up on the...
But that's not statutory.
No, that's not statutory, that's contractual.
So you say the client has agreed that the solicitors can deduct their fees from the damages received up to a maximum of 25% of damages.
Indeed, my lord. And I say that...
But what if he hasn't?
I'm sorry, my
What
lord.
if the client has not had that agreement in the CFA?
Well, much would turn on what other contractual terms were in that. So I don't...
We can't, I mean, surely, I mean, my point is this, that we're not deciding the meaning of the word payment in Section 70 of the Solicitors Act according to what your client has agreed in this case as being a cap on the costs. We have to decide a meaning for the word payment which applies whatever has been agreed between clients at the beginning and what happens then at the end.
Well, payment will always be the payment over of a sum of money. That would be point one, with payment of money from A to B. Whether it then is payment for the purposes of Section 70 is more nuanced, because, of course, what there must primarily be is a Section 69 bill, because there can't be payment so far as Section 70 is concerned, because it's payment of a bill, and a bill has to be a bona fide compliant Section 69 bill.
Okay.
So at that point, what the client has, or ought to have had, is a retainer
At which stage?
at the beginning.
Yeah. I mean, you started talking about bare retainers. I mean, I'm sorry to be difficult about this, but I think we need to start at a slightly earlier place here.
Right.
I think we need to look at the legislation, and I think we need to just be absolutely clear what the decision of the judge was and your grounds for appealing it. I know it's a bit old-fashioned, but at the moment, I think we're sort of dancing around a lot of different concepts. The reason this appeal is in this court is because this question has not been decided for a very long time.
Indeed.
Right. And therefore we can't decide it on a sort of, it's all about this case and this is the way CFAs are done today. It needs to be, whatever we decide, needs to be durable. Because, unfortunately, despite my protestations in Belsner, it doesn't look as if the Solicitors Act is going to be changing anytime soon.
Indeed. Perhaps then I'll go back to where I think I first volunteered.
Yes.
Go back to my skeleton.
Why not?
So we're looking at the core bundle, please, and it's...
We're looking at your skeleton.
Indeed, please, my lord. It's internal page 73 and it's electronic page 86.
It would help me if you just gave me the paragraphs in the skeletons as well.
If I, the order below is set out at paragraph 3.
Paragraph 3.
Yes. And you'll see there that's just a bare statement of the outcome.
Yep.
I then set out at paragraph 4 our position in Precy. And I then set out the statutory basis of the question that the court is engaged with today. At the end of that paragraph and just over the page, I set out section 70. And I've underlined the two elements of that particular statutory provision that relate to payment. And the first in time is 70 subsection 3 little c, which reads, where an application under section 2 is made by the party chargeable with the bill after the bill has been paid but before the expiration of 12 months from the payment of the bill, no order should be made except in special circumstances. And then the main one, which is 4, sub 4, the power to order assessment conferred by subsection 2 shall not be exercisable on an application made by the party chargeable with the bill after the expiration of 12 months from the payment of the bill. So just pausing there, there are...
Should we look at section 69?
This is in the authorities bundle, and it commences at page, internal page 2 of that bundle, electronic 3. I'll stop giving both if it's becoming irritating. And you'll see there that the opening salvo, section 69.
Now, section 69 is the section which provides for the delivery of what is referred to inelegantly and inappropriately as a statute bill.
I believe this has irritated you previously, Mike.
It has. But we'll call it a statutory bill.
Indeed, and I've tried to do that.
No, you did, I noticed. Yeah. But this is the section.
This is the section
that provides for a statutory bill.
Yeah, and I say that this is core because, in effect, one is entitled to have an assessment because one is entitled to a bill.
But you can't have an assessment before you have a bill.
Correct. And so what the bill is the gateway.
Yeah.
And I ought to make this point because it's important. You have to have a bona fide bill. You can't, if a bill isn't compliant with section 69, then section 70 doesn't engage because you don't have a bill.
Yes.
And the important point to bear in mind in this case is, regardless of any arguments that may, and criticisms that may have surfaced throughout, there is no argument against this bill. It has always been treated as a section 69 bona fide bill. So any drifting off into cul-de-sacs about mathematics is unhelpful. We've always treated this as a bona fide bill.
And are the references to letters and all that interpreted in the modern digital age as including emails and so on.
Well, there's different rules about email service, isn't there? And people have to agree to it, and that's
There isn't a problem.
But it's not a problem. There's no issue here.
Well, section 69(2)(c) talks about delivery
Indeed.
by email.
Oh,
Yeah.
yes, it's been amended. That's great.
But we can park with a very heavy handbrake on any notions that we might be saying that something is wrong about this bill. That we're not dealing with that. The bill is accepted as being bona fide. Because we're addressing section 70. We don't get to section 70 without having a bona fide bill of section 69.
Okay, so it's all been beautifully amended in whenever it is. Yeah.
So, my lord, my lady, if we're content, I'll now move back to section 70.
Mm-hmm.
So, what section 70 does is it then sets out a process by which a party chargeable or the solicitor can seek an assessment of the bill. And what it does is it sets out a diminishing right, if I can put it in that way.
Mm-hmm.
In the first month, it's as of right. You have a statutory right, it's under section 70 sub 1, where before the expiration of 1 month from the delivery of the bill, an application is made by the party chargeable with the bill, the High Court shall, without requiring any sum to be paid into court, order that the bill be assessed and that no action be commenced on the bill until the assessment is completed. Just pausing there. In effect, what's that saying is, if you've delivered a bill and within that month the client challenges it, then the court will move to order an assessment and undertake that assessment, and you can't sue for your debt.
Yeah.
Then it diminishes away, because under 2, where no such application is made before the expiration of the period mentioned in subsection 1, then on an application being made by the solicitor or subject to subsections 3 and 4, the party chargeable with the bill, the court may on such terms, if any, as it thinks fit, open brackets, not being terms as to the costs of the assessment, order A, that the bill be assessed, and B, that no action be commenced. So there's then the court has a discretion to potentially involve itself at that stage. And then at sub 4, the power to order assessment conferred by subsection 2 shall not be exercisable on an application made by the party chargeable with the bill after the expiration of 12 months from the payment of the bill. Forgive me. So that's what I'm going to refer to when I do in my skeleton as the long stop.
Yeah.
The remainder of...
So it's very important to know, for the purposes of this right, when the bill was paid.
Indeed. This is all to do with what payment means. And how it's been framed at first instance and before Bourne J by the respondent has always been that there has to be a reckoning at the end. Some form
But
of...
I don't understand the word reckoning.
an agreement, a negotiation and settlement.
Sorry?
A negotiation and settlement.
But I don't even understand the term settlement, really. I mean, these words are all weasel words.
I
which
agree.
are incredibly unhelpful.
Well,
Settlement, negotiation, you know, we deal in contractual relations
indeed.
in this court, and so do solicitors and their clients. And if we start talking about words that don't have contractual significance, then not only will lawyers not understand, but clients have no prospect of understanding. I mean, clients do understand one thing. If I agree to pay my solicitor £5, I have to pay my solicitor £5. They do not understand, if I don't have a reckoning, I will not have to pay my solicitor £5 or whatever. So I really do...
Well, I won't go there again.
No, you need to go there because the authorities go there with terms like settlement.
Well, that's the difficulty.
We need to be incredibly careful what we're talking about. Because anyway, for my part, I intend that after this case, solicitors and clients will know what the rules are
I'm grateful.
under the statute.
My lord, perhaps the language I'm using is unhelpful, but what I was trying to do and clearly failing to do was to show the difficulties that surround this word payment, because it's being interpreted differently by different people. And in the authorities from the 19th century up as far as Harrison and Chew in the Court of Appeal, there is this idea that at the end there's some form of coming together and some form of agreement. And it's referred to in the authorities as a statement of account and a settlement of account. But there's no explanation as what those two mean.
Well, what do you say they mean?
What I say is nothing more than you're agreeing to pay.
So it's a statement of account, the bill, with agreement from the client in some shape or
My
form.
lady, it doesn't even need to be that formal. It could be, if you'll excuse the common vernacular, a working out on the back of an envelope. This is what I think it is. If we agree it, then what I'll do is I'll make a formal bill to the sum we've agreed. In effect, it's an agreement.
Well,
That's
can we
what you're-
just pause there? If you enter into an agreement with your solicitor that you will pay the solicitor £100 per hour worked for work done on your case, and at the end of the case the solicitor has done 10 hours work and can demonstrate that and delivers you a statutory bill saying, I have worked 10 hours, we agreed £100, you owe me £1,000 in compliance with section 69, right? And you deliver that bill. And the solicitor has also agreed with the client at page 64 of the CFA that you may deduct the amounts shown in a statutory bill from monies held in hand. Does there need on the authorities to be a further agreement to you deducting the money, or are you in your rights simply to present the statutory bill and deduct the money in reliance on the original agreement?
I say yes, you are entitled to stand on your original agreement. And what the authorities are doing is addressing a set of circumstances that didn't exist back then.
Well, I think where you're getting to is that payment is a transfer of money consequent upon the delivery of an account and the client's agreement as to the method of recoupment.
My lord, yes, save that I wouldn't necessarily put it in that order.
No.
There have to be the same
The three
ingredients.
the three elements are client's agreement to method of recoupment, delivery of the bill which complies with section 69, and transfer of money.
Indeed, yeah. And it may well be that the transfer of money, my lord, is a subdivision of the recoupment process, but
It's got to be authorised one way or another.
one way or the other. Yeah.
Well, delivery of a compliant account, section 69 compliant account, correct?
Correct.
Bill. So let's not call it an account, let's call it a bill, because that's
Indeed, what it
a
is.
statutory bill. Agreement as to the method of recoupment, method of payment. And what's the third element?
Transfer of funds.
Transfer of the money.
And transfer the money.
The physical payment, it would seem. If there would be no physical transfer, then one could...
No, it could be from client account to office account
Indeed.
or whatever.
Or man comes in with a bag of money, or man comes... Or probably
Yeah.
not anymore with money laundering, but probably wouldn't be allowed, but
Yeah.
there we are. And where I say... sorry if I started perhaps in the wrong place before. I was hoping it would cut through it. Where I say there is a distinction, and I don't wish to sound as if what I'm doing is dismissive of the authorities. That's not what I'm doing. But what I say is actually when you drill down into them, they're simply talking about a place in history that isn't the same place now. The modernity of modern working is that the negotiations are done at the beginning, and the agreement as to what you will pay is done at the beginning. And there's lots of reasons for that. In the case of contingency fees, CFAs, you've got to. And in the case of distant working, where you sign somebody up at arm's length,
Got that point. Yeah.
there we are.
But what you're saying is, and you see what the other side of the line is, the consumer protection line, which says, and I alluded to it earlier, you sign the client, I was going to say poor old client, but you sign the client up to a 20-page agreement full of terms and conditions that the client has no chance of really understanding months or years before, which contain the client's agreement as to the rate of charging, the amount that can be charged, and the rate, the method of recoupment, as you put it. In other words, how it can later be paid. And the client doesn't remember any of that, obviously, because 2 or 3 years later the money comes in, particularly in a relatively complex case, no doubt, like this one. And then the consumer protection approach says, well, that's not fair, because the client doesn't really understand what's going on and doesn't have to make any agreement at the point of payment.
Well, my answer to that is twofold. Firstly, from a consumer protection point of view, the consumer protection is already stated in Section 70. He's entitled as a right to have an assessment of those charges. And if he has a section...
Yes, but does the solicitor have to tell the client at the point of payment of the Section 70 right?
Well,
I mean, in this case, we have a rather difficult document that confuses rights of assessment and complaints.
I'll come to that in due course. I say that it's set out in the conditional fee agreement at the beginning. You have a right to assessment, and it's set out ultimately upon that bill at the end.
No, but what I'm asking is, does the solicitor at any stage have, provided you've got those agreements in place 2, 3, 4, 5 years ago, does the solicitor have to do anything at the point of delivery of the statutory bill except deliver the bill in the form under Section 69?
No, they just have to deliver a Section 69 bill.
And then does solicitor, you say, does not have to draw attention to the right to assessment?
Well, they ought to, because it's a requirement under the solicitor's
Regulation.
code of conduct, yeah. So there's a requirement for them to do it.
And where's that requirement?
Now, you've embarrassed me there, my lord.
Well, you see, this is the problem with these cases. It's absolutely imperative that we understand the regulatory environment.
It's not a regulatory environment. They're not, as I understand it, they're not regulatory required. The Solicitor's Code is just that. It's a code of conduct. It's best practice.
Well, that is a regulatory environment.
Well, it's a subdivision.
Because a code of conduct may result in the solicitor being disciplined if he doesn't follow it.
Yes, but I don't think it's set out.
I mean, what does it say? We can find it online.
Give my back.
It's the Solicitor's Conduct Rules, is it? What are they called?
We're going to get the code of conduct up.
What's it called there?
It's the Solicitor's Code of Conduct. I think it was 2013 was the last time it was updated. My lords, my lady, while you're looking, we're also going to do a quick search. We seem to recall that the question as to whether it was a requirement to place that on a bill was addressed in Garbett and Edwards. So we're just going to...
Was what?
It was addressed in a case called Garbett and Edwards. We're just going to check that, my lord.
No, but I've got the Code of Conduct up, but it's not helping me much. You say Garbett and Edwards we need to look at. 2005, yeah. Yeah, we'll keep going in the meantime.
Shall I keep going, my lords?
Yes.
Thank you. So I bringing this down together, I say that payment is a matter of the contractual provisions of the initial retainer. And in circumstances where they provide for, whilst I hear what my Lord Master of the Rolls has to say about 20-page or 47-page documents, the protection for the client from a consumer protection point of view is writ large in Section 70. As of right, they can obtain an assessment.
Well, can they? If you've agreed that your solicitor can deduct his fees from the compensation or the proceeds of sale or whatever, you're no longer within Section 70, subsection 1, are you? You've got to show special circumstances
No.
under 2.
No, Section...
Under 3, rather.
Judge, no. My Lord, if one looks at...
Oh, is it? No, it's 2, is it? So you can apply...
The starting point is this diminishing right. You have an
So
absolute...
under subsection 2, you can still apply within a month, but the court can impose terms.
Indeed, but you have an absolute right, my Lord,
Yeah.
within the, under 70 subsection 1.
Yeah.
And it's absolute. It's written in clear terms. And not only is it written in clear terms, you'll see that there's a substructure to it, which is that the solicitor can't sue on the debt either. They can't commence proceedings. So even if there was they wanted to stand on their agreement, the client still has a right to ask the court to intervene.
But isn't Section 70, subsection 3C applies where the bill has been paid?
But 12 months hasn't elapsed.
Yes, but so no order is to be made except in special circumstances.
Indeed.
So isn't that what I was saying? Once the bill's been paid, you have to show special circumstances. Is that not right?
No.
No?
No, Section 70, subsection 1 is as of right.
No, you have to show special circumstances after a month.
Yes, after the month, that's my point. But within the month, the first month
No,
is...
within the month you've got an absolute right. 0 to 11 special circumstances, 0 to 12, 1 to 12
Indeed.
special circumstances, and then you're out.
You're out, it's statute barred.
Statute barred.
Yeah.
So,
And can I make this sort of, this point, that one of the problems is that if you don't have a broad ability to be paid, then that long stop never accrues. The only way it could accrue is by the solicitor either expressly getting the client's agreement to something, which they may ignore the client, which is the point alluded to by Bourne J below, or you would, as a solicitor, have to sue on each of those bills as the, under 70 subsection 2, as the solicitor, you'd need to make an application. So you'd have to have all your bills brought before the court then tax that bill, and then what you would then have is an order of the court that you could then enforce. And so this ability to have payment is vital.
so what the judge says is that the cases impose a need for settlement of account, which he says in paragraph 30 was what they have held to be necessary.
Mm.
So what is the settlement of account that he said the cases required?
Well, I'm none the wiser, he said very boldly. Having read the authorities, that it is a phrase which seems to have its genesis in the early 19th century and then is repeated. But as to what it means, it's very scant on assistance. And you simply have this repetition of phraseology. And I know my Lord the Master of the Rolls is somewhat quite properly troubled by this use of loose language. But it's replete with loose language. We have this idea of a bare retainer. We have this idea of
You have this idea of
a bare retainer.
a bare retainer.
We have this idea of settlement, a statement of account becoming a settlement of account.
Well, I mean, a bare retainer, I think one understands as being an agreement that the solicitor will act in return for remuneration, full
Indeed.
stop. That is fine. I mean, in one sense, we get it. But we're not talking here about just bare retainers.
No.
We're talking about bare retainers, cases where there have been detailed CFAs, cases where there have been detailed non-contentious remuneration agreements, etc., etc. And we need, I need, in dealing with an appeal from a judge who says there is a requirement according to the cases for a settlement of account, to know what he's talking about. So I think we need to look very carefully at the authorities and his judgment.
Well,
Sorry, I found a case called Earlham in which His Honour Judge Gosnell says, both councils have advised me there are no regulations connected with the Solicitors Act or Code of Conduct arising from their obligations as a solicitor which would oblige solicitors to explain to clients that the effect of the service of an interim statute bill starts the clock running for a potential Solicitors Act assessment and that there are different time limits. I don't know if that helps.
My lady got it in one. When was Earlham? It's not in the 19th century.
2022.
2020.
It's His Honour Judge Gosnell.
my learned friend is tucking my gown to tell me that she was in the High Court in front of Bourne J yesterday, and the very point came up, and she argued that.
She argued that.
So it seems to be the
But
case.
was she right?
We don't know yet, but it seems to be that is the common understanding. And I've also had the point put to me about mouse and cigars and withers, which again is in there, that there doesn't appear to be a regulatory or
So there's
statutory.
no requirement on the solicitor
On
to
the
inform
solicitors.
the client of the right to an assessment.
No, what the authorities do speak of, my lord, is that there has to be a bill that the client can take advice upon. There are a number of cases in which the court
It has to be a bill.
a bill that the client is a sufficient bill.
So a 69 compliant.
Yes,
bill.
it has to be Section 69 compliant, and that has some nuances to it in the authorities. That there has to be sufficient information, etc. And in effect, what they're saying, so they can take some advice on it, because it isn't necessarily, my lord, my lady, a light on, light off. You might get a bill of costs and say, well, I've had a look at my retainer, and it seems about right, but it does seem on the high side. I can't remember that bit of it. And you may say, well, should I challenge this? And you may go along and get advice as to whether or not it would be something you would wish to challenge. So it's right that the bona fide Section 69 bill has to be sufficient. But once you get over that Section 69 bill, and they have it, and it's compliant, then their right crystallises. And there's no obligation to impose upon them, or to put a different way, to encourage them to have it assessed, because there's a cost to that process for either side. Unless the bill is reduced by the one-fifth rule engages, then it is in all likelihood the presumption that the client will pay for the privilege of that assessment. And so that would be heaping costs upon costs. The consumer protection provision is provided by the Act. And whilst much of the 1974 Act can be sometimes impenetrable or difficult to reconcile in the modern era, Section 70 is actually fairly straightforward. It is a diminishing right to come before the court, to ask the court to inquire into the amounts claimed within a bill of costs.
Can I ask you about paragraph 25 of the judge's judgment? The judge did what I have to say, always slightly cautious about. He said the relevant principles of law are as follows. And he then says that, having summarised Section 70, let's assume correctly for the purposes of this discussion, that retainer by a solicitor of his costs out of money in his hands belonging to the client can amount to a payment under the legislation, but only if there has been a settlement of account between the parties. See Mr. Justice Neville's case. Now, what does settlement of account mean in that situation?
It doesn't. You'll become none the more better informed by reading the judgment, because they all differ when they use the term. In some of the authorities that are before this court, you will see that settlement of account is referred to as being a process by which, at the end of the litigation, the client sits down with the solicitor in their office. They go over the fees that are going to be charged and reach some form of agreement.
Right, but all that presupposes, does it, that there has been no existing agreement?
Indeed, that's where I started. That's the nub of all that I'm saying. And this point it seems to have persisted.
So you say paragraph 25, Roman 2 of the judge's judgment is wrong.
I do.
And overgeneralized.
Well, I think it has two difficulties. The first is, I think it doesn't explain what it means. It doesn't advance matters at all. Somebody reading that and coming to it afresh would not still understand what that word means or where it comes from.
Is anybody going to say that's not in your grounds of appeal?
No, as luck would have it, I have a general sort of criticism, and it's also in my skeleton argument. I think
Sure, that's not luck, Mr. Rowley.
Forgive me, my lord.
No, keep going. So you say that's wrong, and you would also say that Ingle doesn't support it, and the Master of the Rolls, I think, was sitting at first instance in Ingle, was he?
Yeah.
So he doesn't bind us.
No.
No.
And Ingle is it's a very peculiar case in any event. I mean, its peculiarity may not lead to trouble.
Disappointing, isn't it, that 178 years later or something, if I'm calculating it right, the Master of the Rolls is still sitting on cases like this.
Lest it trouble you, I do say that Re-Ingle is very unique. In Re-Ingle, you'll remember.
It's tautologist, as you know.
Yes. Well, the client was illiterate.
Yeah.
And there'd been an agreement to sign away the client's rights to some shares as payment, when the value of those shares was not known, and nor was the amount that was crystallised as to what was to be charged.
So it's jolly unfair.
Absolutely unfair.
But it's nothing to do with this.
No, it's nothing to do with this at all. It just doesn't go anywhere. And I do rather wonder if it was one of those cases as well, my lord, where you'll recall that it was not until Harrison and Chew in the House of Lords that it was finally put to rest that the courts didn't have an inherent jurisdiction over solicitors that could moderate section 70 subsection 4, and the court then restricted itself very clearly that it would only have the jurisdiction to involve itself in circumstances where there had in effect been some form of manifest overcharging or fraud, and so it would only be in the most egregious circumstances.
Can I just ask you to be clear, looking at paragraphs 25, 5, sub 5, I think Harrison and Tew is a case on its facts, right? It's just stated by the judge to be an example. But in 5 and 6, the judge states the law as being that there can be no payment until a bill of costs is delivered, per Lord Romilly, sitting on appeal, I expect, and applied in Louis Foster. Do you accept that?
Which subparagraph am I looking at, my lord?
Subparagraph 5,
thank
or
you.
paragraph 25, and I'm going to ask you whether you accept 6 as well.
Well, 5, you're going to raise your eyebrows because I'm now going to give you an answer that's nuanced, and I apologise in advance for that. Payment in the sense of Section 70, subsection 4, has to be one thing. And insofar as Section 70, subsection 4 speaks, it speaks to a bill. And so there must be payment of that bill.
Yeah.
And I think that's where that line comes from.
So there must be a bill of costs delivered.
In other words, it's a linear process. Because payment is a creature of Section 70, subsection 4. That's what we're analysing.
Well, there can't be a payment for the purpose of Section 70, I think you say, in fact you told us before, until such time as there is a bill to which that payment can be referred.
Indeed.
And subparagraphs 5 and 6 of the judge's judgments are dealing with transfer of money, as it were, before and after delivery of the bill. And I think what he's saying is the time under Section 70 can't start to run until a bill has been delivered.
And I agree with that proposition, because we're dealing here with the time periods.
Yes, but if there is, he says, an agreement and actual payment before delivery of a bill, then the bill, the delivery of the bill, can validate and make the payment effective as at the date of that delivery.
Yes, I agree with that point.
You agree with that?
And that was the point I made. I was directly asked by Mr. Justice Bourne where I said time ran from, and I said once this payment of the bill has been delivered.
So you accept 5 and 6 effectively. I don't think it's a nuance.
For the purposes of Section 70, Section 4.
Yeah, for the purposes of Section 70. And your criticism of the judge's statement of the law, because what Lord Justice Dillon said is concerned, I think, with the facts of that case. I'll be corrected if I'm wrong. So your criticism is of sub 2 and sub 3 of 25.
Yes, it's the notion that there has to be, and I'm going to use an inelegant word again, please forgive me before I use it, of being some form of account taken. It isn't. It's a much more linear point. You have a right to charge. You charge and you deliver a bona fide Section 69 bill. Upon delivery, you can then, or you could do it before, you take payment. But the time for the purposes of Section 70, subsection 4, runs.
The judge then moves on, Mr.
Mr. Ralph.
Mr. Ralph, I'm sorry, I've got it in my head that you're called Mr. Craig, and it's not going away anytime soon.
My Lord Master of the Rolls, most of my life I've spent it in the waiting rooms of various places, not getting up because they're shouting Mr. Craig, only to be told that they've been shouting me for a long time.
The problem is that Craig is
it's a forename and a surname.
Well, that's right. Okay,
yes,
accept my apologies.
No,
I don't
please,
do it on purpose.
Please, you don't need to apologise.
You in paragraph 26, the judge says that Miss McGungle had submitted that there was no sufficient informed agreement between the appellant and the respondent for payment to take place.
Yes.
And there are a whole raft of authorities, some of which may be in the bundle, but I remember one of my predecessor, Lord Etherton, who said that you did need informed consent in some contexts where payment of solicitors' bills were concerned. Now, you'll remind me of the case.
Well, my Lord, the point here is that this point is at the point of the retainer, so it's answered more effectively by, we say, Belsner, because there's the agreement to pay is part and parcel of the primary negotiation.
I think the informed consent point arises in a different context. It arises, as I recall, on the assessment itself, because under CPR 46, if the client has agreed to the incurring of a particular item of costs, it is presumed to have been reasonably incurred, or whatever the phrase is in the
Indeed.
And it is in that context that the cases talk about an informed agreement in order to raise the presumption.
Yes. My Lord, you have it. It's an assessment.
That's when the informed agreement comes.
It's an assessment point. It's not
Wasn't
a...
the case, the one you mentioned earlier, Harbart or Henry or something like that, began with an H,
H.H. Herbert and H.H. Law.
Herbert and H.H. Law. Isn't that where the Master of the Rolls talked about informed consent?
That was to a success fee, where the success fee and the reasons for the success fee weren't communicated to the client.
So Miss McGungle submitted, as I say, that in the present case there was no sufficient informed consent. So there wasn't enough consent for the deduction to amount to payment under Section 70. And she said that on the basis of the law we've been talking about settlement of account.
Indeed.
Now, what do you say about that?
Well, I say that that's just wrong. It's introducing an arbitrary test.
But you were going to say something stronger than that.
It's
You say it's wrong.
I say it's to introduce again an arbitrary test into what needs to be something that can be understood by the profession and clients.
Do you mean a gloss, or do you?
Yes, I do mean a gloss. Yeah.
Right.
It's using language that isn't precise to seek to undermine the contractual agreement that has long been settled.
Okay, so then the judge went on.
My Lord Master of the Rolls, you'll see at paragraph 29 of the judgment, where Bourne J recognises that what I'm saying is what I'm repeating here.
Yes, yes, indeed. Then he goes to the facts and says in 31, on the facts of this case, the retention did not amount to payment because there was no sufficient settlement of account between them.
Indeed.
So what he's saying is there is an additional requirement, whatever the agreement is at the beginning, for quote unquote settlement of the account, and you say that's wrong.
I say that's wrong. I say introduce a gloss.
And that's disappeal.
And that's this appeal. It all comes down to, my learned friend says that there has to be a specific agreement. And I say to a specific sum. I mean, that's the nuance, actually. It's not just a specific agreement. We should call it what it is. It's a specific agreement to an identified and specific sum. And I say that's a complete red herring, because a specific sum is not what has anything to do with Section 70. Section 70 is you're given a bill and you've got a right to challenge it. And the process of assessment gets you to a specific sum, which could be either the whole of the bill.
Well, you've got to know what to pay.
You've got to know what to pay, but my point is that for the purpose of Section 70, Section 70 is about assessment. And even if you got to an agreement where you said, actually, well, we'll use your analogy, if I may, my lord, the £100. You could get the bill for, I've agreed to pay £100. I get the bill for £100. And within a month, I think to myself, well, actually, now I've thought about it. I've looked at that just doesn't seem right. You have an absolute right to go and have that assessed. And as part and parcel of that process, the inquiry into whether or not you're given consent, whether or not it was fair and reasonable, would all be part and parcel of that inquiry.
But what seems unjust or out of step with modern life is that this process can kick off, leaving only a month for the client to have an absolute right to go to court and get advice in order in the meantime before certain limitation restrictions kick in. And there is no requirement for the bill to be discussed or considered between solicitor and client if there has been prior agreement as to, or even if there hasn't been prior agreement as to the method of charging. So you may have a delivery of a statutory bill saying I'm charging, you know, fee earner A at £100, fee earner B at £200, and so on. And these are the hours which you've never known before as a client. You get a great big complicated bill you can't possibly understand, with a figure of 50,000 at the bottom, and that's it. You get it. It's deducted off your money in the solicitor's hands, and there's even no requirement to tell you you can get it assessed, even if that's good practice. So you can see why Ms. McGungle says that's not very fair.
Well, there is always going to be, at the extremities of everything, a hypothetical set of scenarios in which you can paint.
It's not all that hypothetical. I mean, this is the normal situation. Solicitors charge, they don't normally charge 10 hours work of £100, whereas the client knows the 10 hours work and what's been done. So, you know, this is the normal situation. And so what's really being said, is it, I mean, I'm asking, is that this Section 70 is not fit for purpose in 2023 with the new digital era you've so eloquently spoken about, Mr. Ralph.
Permit me to push back a little bit. I'm not here to give evidence. That's no part of my role.
No.
But the notion that that we have solicitors who are representing clients on no form of a formalised retainer, with no reference to knowing the client knowing what the hourly rates are.
No, but even if they do, I mean, let's assume everything is done perfectly, as let's say it was here. I haven't looked at the retainer, but let's say it was. The 2 years after the case starts, the client has, with his long-distance solicitor, only had a few emails and been on the phone, and he gets presented with a bill, which may be perfectly legitimate, for £50,000, because the solicitor's been beavering away with the doctor and, you know, putting together all the ancillary expenses and blah, 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 and negotiating with the insurers on his behalf. They know nothing about any of that, and the only redress they've got is for 1 month to go to court.
No, that wouldn't actually, I think, in your scenario, as you've on your hypothesis, I think there would be longer. And the reason for that is that, in effect, they've been given no information at all. And so, on your scenario, they would be able to go to court and say, I'm going to plead special circumstances.
Well, I know, but I mean, what I'm putting to you is the reason why this concept of settlement account commended itself to the judge, based on the old authorities.
I don't know the reason why it commended itself to him, beyond the fact that he makes reference to a 19th century authority. But for the reasons I've already articulated, I say that that's the wrong lens.
But is this, I mean, is this a good way to proceed? You have made your points, if I may say so, incredibly clearly, and we've got them, I think. I think we need to hear from Miss McGungle why she says this concept is the right concept and entrenched in law. She may think it's a good idea to take us to some of these authorities, particularly if they are said to bind us, or even if they're not. And then we'll come back to you and give you full time in reply.
I'm very grateful.
Is that okay? Kim? Yeah? Yeah, okay. Thank you very much. Yes, Miss McGungle.
Thank you, my lords and my lady. Firstly, there was an issue raised by my Lord Master of the Rolls in respect of the actual extent of the appeal. My learned friend responded to that by saying it's all very generic within the grounds of appeal and he thinks it's covered. I would, however, like to take you to those grounds of appeal.
Yes. In the core bundle.
In the core bundle. So if we're looking at the e-bundle...
Page 15.
Yes. So we can see there the grounds of appeal as set out. And this is against the backdrop of Bourne J's judgment as referred to in detail by Master of the Rolls. We can see point 1 there refers to this reasonable time test that we haven't yet got to. And point 2 refers to a sufficient clarity test. Point 3 then refers to an alternative point about the facts. So point 1 and 2 are points of law, point 3 is a point of fact.
But is that
finding of
right?
fact.
Because you've got to decide what the requirements of Section 70 are before you can decide whether on the facts they were met, haven't you?
Yes, but in terms of 1 and 2, the legal points, the points of law, they refer to these, I would call them tests in respect of the presumed agreement or the presumed settlement of account by the client. And I take a step back from that to say that the argument that has been had so far about this idea of settlement of account and the reference in Bourne J's judgment to settlement of account and going on to reference a specific amount of retention of monies, that's a different point and it's not challenged in the grounds of appeal. So settlement of account as a idea or as a as something that Bourne J considered to be a concept is not challenged.
But this is going to be a fairly unpopular submission. It seems to me that what is being challenged is the contention that there needs to be any other requirement apart from the statutory requirement of payment. And we're all here to determine that, knowing that the costs judge and the judge on appeal thought this was an important point. So if the foundation of his reasonable time and sufficient clarity tests, if that's what they were, is settlement of account, then I think you've got to tell us why that was right or wrong.
I raised it because of the content of the grounds of appeal.
Indeed, we've got it. But my Lord's point is also one you'd have to tackle in answer to that.
I'm grateful. So I think it would help if we do have a look at the authorities.
I'm sure.
Yes.
It's often.
So if we could go to the
Do any of them
authorities.
actually bind us? Do any of the authorities actually bind us?
Yes.
They do. Right.
And I think it's probably easier if we go through them in the order in the bundle rather than chipping and changing.
Well, can we go in chronological order? Whatever, yeah, they are in chronological order.
So the first case that I refer to is re Bignald. And this was a decision by Master of the Rolls, Lord Langdale.
Yes, and this is, he's sitting alone, is he?
He is.
So this does not bind us. Right?
No. But this is the first case that I refer to in terms of reference to this settlement of account. There is highlighting in this bundle that was agreed between the parties that hasn't seemed to have made its way to the electronic bundle. There was also elements missing. The first highlight should be 347 E, electronic bundle 13 and page 12.
Can you just tell us, okay, a mortgagee's solicitor retained the amount of his biller's costs out of the produce of the sale?
And the mortgagor, who was ultimately liable, said, I never agreed to that.
Yes. So there's a relationship that exists here between the parties.
But no prior agreement.
Well, that there's an agreement in respect of the presumption of their relationship.
Why? The solicitors were retained by the mortgagee to sell, and ultimately the costs fall on the mortgagor, the borrower. And he said, I never agreed that you could deduct out of the proceeds of sale.
But in that scenario, that there isn't, as my learned friend would refer to, an agreement between those two parties. But what this talks about is the mere retainer of monies out of hand, and the fact that there is a requirement for a settlement of account. So that Reading reckoning that my learned friend didn't want to push terminology with, the fact that there does have to be an area of an agreement. My learned friend will say...
What does this all mean? I mean, this is just a question. It's a bit like reporting something I asked you. There's the master of those. This is the bit you rely on. You say that the solicitor is between himself and client has retained the amount of the bill. I've never hitherto considered that the mere retainer by a solicitor out of monies in hand of the amount of his bill amounted to a payment unless there's been a settlement of account. What does that mean?
So what I say settlement of account is exactly what was being discussed with my learned friend before, and that is an active and engaged process. So it can't just be...
Active and engaged process.
What does that mean? I mean, is that another requirement for an agreement at the point of payment?
Ultimately, to take it back a step and looking at the scenario where there is an agreement, as is here, with a CFA to an amount, 25% it is here capped, that's the initial agreement. And then there's a period of time as the claim progresses. Then there is a time at when the solicitor is aware of how much their bill is, or potentially is subject to assessment. And it's at that point that there has to be agreement, active engagement from the client to say that I either agree to this or I dispute it.
But what if they do nothing? Your client did nothing. The solicitor sends the bill, and nearly 2 years goes by.
Well, that's what the subject of this appeal is. So, and that's the nuance
what's
that
the
was
active
added.
engagement that you're looking for?
So there has to be a sitting down, effectively.
So if the client just puts his head in the sand and does nothing, that will scupper the payment crystallising.
Yes.
All clients can just do nothing, and no payment crystallising.
No. As in, if he puts his head in the sand, it scuppers his right to assessment.
Well, why? He hasn't been actively engaged.
He hasn't been actively engaged, but that's the caveat that is added here by Bourne J to say that there should be a period of time in which the client can either accept or reject. And once that period of time is gone, he's taken to accept.
21 months isn't long enough.
Well, that's also predicated on the fact that there has to be sufficient clarity for him to understand that he has a right to do that.
But where does this period of time come from as a matter of law? I mean, legal requirements, don't really just sort of spring out of fresh air.
No, but it gives clarity to both parties in terms of, well, there is a period of time. It will be case and circumstance specific, but at least there is, what my learned friend says is that there's no long stop there and the time can run ad infinitum. What this adds is that there's a reasonable period in which a client can agree or disagree, or they are taken to have agreed.
So what, as a matter of law, is the starting point of that period of time? and what is the finishing time?
Well, in Bourne's judgment, it's what is considered reasonable in the circumstances of the case.
So where is it in his judgment? Can we look at that?
We go to the core bundle. His judgment.
Would it just give us the powers? We know where it is.
So he goes on to say, paragraph, after he speaks about settlement of account, he then goes on to say,
Sorry, where are you?
sorry, paragraph 34
It's 39,
refers
isn't it?
to missing settlement of account.
It's 39, I think.
Sorry, E43, page 37. That's when he starts to talk about settlement of account, and then over the page,
37, he says the solicitor must give the client a reasonable time.
yes.
Para 39.
In the situation, I do not consider, in the preceding paragraph, he's talking about the situation where the client buries their head in the sand. And then he says, in this situation, I do not consider that the client could prevent payment from occurring simply by ignoring the bill and letter. It must be, in my judgment, be possible for a solicitor to give a client a reasonable time in which to notify any dispute, after which agreement can be assumed if there is no reply.
Well, that's just saying what could happen. It's not saying what must happen.
Yes, but
I mean, the first sentence is his determination. The client cannot prevent payment from occurring by ignoring
yes,
the bill.
answering the solution of the client putting their head in the sand.
So that's what my lady was asking about. And then the problem in this case is with the terms of the letter. This paragraph did not clearly identify that the appellant had a choice between declining to agree the deduction, in which case the respondent might apply for its own bill to be assessed, and agreeing to the deduction, in which case the appellant could still apply for the assessment of the bill if he wished. Where does that lay down a requirement for a reasonable time? That just simply says he should have told him that.
Well, the reasonable time requirement is, as suggested by my learned friend, a way of avoiding time running ad infinitum.
I mean, the real ratio, I don't know whether it is, but it seems to be in 41. I therefore conclude the respondent did not inform the appellant with sufficient clarity that he could object to the deduction within a reasonable time, failing which it would be taken to be agreed subject to his statutory assessment rights. So it seems to be the case that if you don't do that, you can't have payment.
Yes, that's
That's what he's saying.
his conclusion.
But why? I mean, what? That's because you haven't got a settlement of account, is it?
That's because there is no process of agreement to this specific retention.
So the ratio is in 41 and the first sentence of 42, really. In those circumstances, I've concluded the payment was not affected by a settlement of account.
Yes.
But why wasn't payment affected by a deduction from the account in accordance with the agreement in the CFA?
Because in the circumstances, you have a CFA that's taken out. Then you have a case that proceeds with a client who is not going to be, as my learned friend said, most clients acting under CFA distance regulations, and the engagement is limited. So at the time when there is a realisation about how much the client has got to pay, there should be involvement of the client at that point, and he should be informed.
Well, I mean, with great respect, I couldn't agree with you more. But we're dealing with the law here, and you need to show us that there is such a legal right. Now, you may also say, if there is no legal right, this court should be suggesting there needs to be one. But that's something that is for others, isn't it? I mean, you know, I've been pretty public in saying that I think the Solicitors Act is not fit for purpose in 2023. And you never know, you might get another judgment saying that not too long from here. But what we're concerned about, which I think you need to tackle, we've seen Bignelled, and I think we need to go through the authorities to see if there's anything binding us to this principle of a settlement of accounts.
Well, I'll go through the...
Now, is there anything else in Bignell apart from the Master of the Rolls delivering himself of a question? And I can say for myself, I would be very miserable if somebody suggested a question asked in court made binding authority 170 years later.
Ingle is the next case that
Yeah, I take that
reference
as no.
is made to, and yes, Ingle is the case that refers to there being a lack of acquiescence, well, mere acquiescence rather, and a lack of agreement. It again goes to this proposition that there should be an agreement between. So in Ingle,
It's also not binding, is that right?
it's not binding, but it gives a flavour.
Yeah.
It gives a flavour, and this again is taxation, where the client and solicitor came to an agreement in respect of shares. Again, it was argued that there was no payment. And reference there, we can see at 278 and 279.
Well, 278, the Master of the Rolls seems to say that the agreement's not binding. Doesn't preclude taxation. Because Mrs. Nadine didn't understand it.
What it goes
Sorry,
on
I'm
to
not-
say.
Where is that? If somebody could
It's
tell
on.
me. Is it where it's in the reserved judgment?
Yes,
Yes.
page 278 of the original pagination from Bevan.
On the
Ah.
left-hand side.
He says, the client on her part agreed to the amount of the bills of cost. Such an agreement might have been perfectly good if entered into between persons who understood their situation, but such is not the case here. She was illiterate, the bill was delivered, she had no means of knowing whether it was a proper bill, impossible to obtain advice, the value of the shares wasn't known.
And then it goes on.
And then he says, right at the bottom of that page, at the beginning of 279, as to payment, there was none.
Yes.
But why does he say that? He says payment must be either actual payment in money
Or an agreement by the client on the settlement of accounts between the solicitor that the amount shall be retained. So that's where I talk about the specifics of an amount to be retained.
And do you say amount means quantified pounds and pence or something?
It means a specific sum.
I don't understand that sentence. He says payment. The solicitor was to retain out of money to be received by him the amount of his bill. Payment must be either by actual payment in money or an agreement by the client, comma, on the settlement of accounts between him and his solicitor, that the amount shall be retained. So you've got two choices for payment: actual payment in money.
Yes.
Is that can't? Oh, okay. Or an agreement on the settlement of accounts that the amount, a specific sum, should be retained.
Yes. And that's the point that I make.
That's the foundation of everything, is it? That sentence.
I mean, Ingle was where this case about questioning payment started because of the reference to the specific sum. So Ingle is effectively the genesis of the argument as to payment by retention not amounting to payment.
Mm. Anyway, the next question was much more difficult, so that's good. He says, the next question is much more difficult.
Yes. So that was a pithy summary of the position.
But, I mean, do you say that has been understood to be the law ever since?
I do.
You do?
I do.
I mean, does it appear in the costs books?
It appears in the White Book. So if we go to volume 2 of the White Book, the Solicitors Act is set out there. And it's also been amended, so the current draft of the White Book includes Bourne J's judgment.
Well, that I'm afraid won't cut much.
No, I
mustard
appreciate
on
that,
the
but I'm
peel.
just saying it's in. I'm saying you'll see it when I take you to it. I'm not saying that's the end and I sit down.
No, I think I get that. But it's referred to as being which page of volume 2?
2427 7C 120, which talks about payment of a bill.
Right. But there was no valid agreement, so this is really overturned. So in this case, there was no valid agreement.
Oh, sorry, no.
So we didn't get to payment because there was no valid agreement.
No, but the reference to this issue of agreement to a specific sum. And
No,
that's...
what I mean is there was no valid agreement to the retainer that the payment should be made in the first place. So there was no agreement to the charges or the retainer. So in those circumstances, or deduction, in those circumstances, the fact that in order to have payment for the purposes of the 1840, whatever it is, Solicitors Act, you needed another agreement on top of that is overturned.
Yes, but what I would say is that arising from that is the reference to the specific sum, and that's what's important.
Well, he doesn't actually use that phrase, does he? He talks about the amount.
Amount, yes.
So you would say, going back to
That
the
the
example
amount-
that my lord gave, that if the client agrees that the solicitor can charge £100 an hour, there has to be an agreement on the number of hours worked before the solicitor can deduct.
Yes, and in the circumstances of a CFA, 25% on amount to be determined is the specific sum. So that's my use of the word specific sum, but an amount. Because it can't just be an amount in a vacuum. It has to be a quantifiable amount.
Okay, so can we
Or
see how,
quantified, rather.
can we see how re-Ingle works out in the future cases?
So as the cases, the next case in time is Sutton and Elliott.
Oh, it's Hemming, according to this.
Hemming is very difficult
I can't even read it.
to read.
I think you should have been emailed a PDF from the library, which you can enlarge on your computer. My clerk should have sent it to you, no?
Yes.
No.
I think my lady's
got
got
it.
Have you, could you send it to me? Send it to me.
My clerk printed it off rather than sending it to me, sorry.
I mean, is Hemming, is it relevant? I mean,
It's not help.
That's in bigger type.
I won't be able to.
It's in bigger print.
Yeah, no, I can't read that.
No?
There is reference to payment, but
Sorry?
I can ask her to email it.
Yeah, could you? I'm surprised I haven't got it if people think they sent it.
Well, this is another mortgagee case. Mr. Hemming got 3 bills.
yes.
Payments had been made on account. And then another bill was delivered to him in 1856, when the solicitors, on paying him some monies, deducted the account and a receipt was given. Then he asked for more detailed bills and got them, and then he applied to have them taxed.
Yes, and the point of this is...
And Chief Justice Coburn said, it seems to me that what took place amounted to payment, unless there had been some gross overcharge. They had money in their hands raised by mortgage, when in 1856 they came to a final settlement in which these bills were included. Mr. Hemming submitted to those charges so made, acknowledged the account and kept the balance in liquidation. And he said, it goes on to say it's the ordinary case of a man accepting a balance in liquidation of an account, and I think therefore these bills are paid and finally settled. Mr. Justice Williams agrees. Mr. Justice Crowder says this is a payment of claim, costs and charges which are made within the ordinary rule of a bill rendered and balance accepted which amounts to a payment. And Mr. Justice Willis says there's nothing to prevent a man, sui juris, settling his attorney's account without taxing it. He may pay if he like, and if that is not to be conclusive in the case of an attorney, just as that of a grocer or butcher, then we should have a man after a bill had been delivered coming here with numerous objections which may be raised to upset the settlement.
This is the grocer or butcher case. Very good.
And the issue in that case was gross overcharge.
This doesn't support
No.
Lord Sir John Romilly. No. Okay, so now we do go on to Sutton and Elliott.
Does the Court of Common Bench bind us?
Sorry.
Does the Court of Common Bench bind us?
No.
No.
And then we got another common bench case, I think. Sutton and Elliott.
Yes.
Also pretty illegible, but we'll do our best.
Again, going in the e-bundle, the reference there is again to this idea of settlement.
Well, I'm sorry, just to pause a moment. I think this is a case in the Court of Appeal,
Yeah.
according to the report.
Yes. And it's not illegible either. No, found it.
Apologies, I've got 2 Hemmings.
We're on Sutton and Elliott now.
So Sutton and Elliott, this is Master of the Rolls Brett dealing with this matter, and the issue here is there are multiple bills, and the difference between which bills can be assessed and which can't, and reference at 378 following the Master of the Rolls talks about what can account or amount to payment. It starts, as regards to the last 4 bills, the account was handed to the client, or rather to his solicitor, and such account, after taking into account these 4 bills, a balance was shown in favour of the client, and the amount of that balance was paid to the solicitor, who accepted the balance as correct, took the money for it, and more than 12 months elapsed after such payment before application was made for delivery of a bill. And the question was whether that prevented order for delivery in time. Going over the page, we can see reference to payment of any such bill. And then moving down that page, it says, if a bill has been paid and more than a year afterwards has elapsed, it cannot be ordered. Otherwise, after a bill of costs has been delivered and paid and settled, a client may, at any times afterwards, have the whole matter reopened because the bill was not a signed one. So the issue in this was about a bill, whether a signed bill could be taxed or assessed.
But if we go back to the facts for a moment, there are 3 bills
Yes.
which weren't signed, weren't paid, but the solicitors stopped for such costs monies which had come to their hands. And the Master of the Roll says that those bills could be taxed because they weren't signed and they weren't paid. It's the 4 bills that can't be. But as far as one can tell from the facts, is this right? There was no prior agreement by the client that the solicitors could deduct their fees from the bills.
No. But there is again reference to this settlement.
Is
Not
that
settlement
different
on
from- is that
account,
different
it's
from
being
agreement?
settled.
Is that any different from agreement?
I say
There's no prior agreement. The solicitor says, well, I've deducted X from the monies I've got for you. And the client says, all right, I agree that. Why is that so different from a case where the client says in advance you can deduct your fees from what you get?
because of the need to, the knowledge of the specific sum that I referred to before, and the difference in the knowledge at the beginning, and then the difference of a quantifiable sum.
So you try and distinguish this.
Yes.
I mean, it could be said against you that this case is entirely against you. This just says if you accept money which deducts a bill which is in your hands and complies with Section 69, then you have 1 month to get it taxed in the usual way because you've agreed to the bill, irrespective of whether you've agreed the charging before.
But that's an agreement to a bill that refers
These
to
were
a specific
statutory
sum.
bills. These were compliant. These 4 bills were compliant statutory bills.
So there was reference within them. They contained a specific sum.
Yeah, you agreed it by allowing deduction. So how does that help you to require for another requirement of settlement of the account?
Because what you're agreeing when you agree the deduction in the CFA is not that specific sum. You don't have the requisite knowledge. In these cases, it was referable to a bill.
Because the statutory bill had already been sent. I mean, I can see that it's not inconsistent directly with what you're submitting for, but it doesn't support what you submit.
No. But they're referable to a bill and agreement or settlement occurred.
Anyway, it doesn't bind us to find in your favour, is that you'd accept that?
I accept that it's a Court of Appeal case, but
Well, it binds us, but what it finds
Yes,
is
yes,
ratio
yes.
is not
Yes.
not what you want, you need. Okay, good.
the next case is the case of West. And this is Cave J, page 30 of the bundle.
I now have a super copy of the Common Bench case, which is entirely legible. Thank you. West, yes.
So page 30 and 31 of the e-bundle. And we can see at 107 reference there. There's reference to Bignold and Lord Langdale. And then we can see the reference to Stedman and Collett. And the reference of...
Are we in the judgment of Mr. Justice Cave?
Yes.
But what he says at the top of the page is there's been no bill and no agreement, therefore no payment. He doesn't say that the agreement has to come after the delivery of the bill. There is in fact neither. This is a case, as he says at the bottom, towards the bottom of the page, that solicitors simply help themselves to some money.
Yes, but what it does refer to is settlement of accounts. I'm just referring you to the notion of settlement of accounts.
Sorry, where is that?
So if we look...
Second hole punch on 107.
The page before my lord referred to. My lord referred to page 107 in the report.
Yes.
On page, where's the settlement of account referred to?
The reference to settlement of accounts is, as my lord referred, 107.
It's in the middle of the page.
Oh, sorry.
It's just after Stedman and Collett.
Now as to the retainer.
Yes.
Now, what does Mr. Justice Cave mean by the retainer? Does he mean the contract of retainer or the retention of the money?
That's a question that I hadn't...
No, I think he means retainer.
Retention, does he?
No, I think he means...
No, he does. He does. He means the agreement. Or the...
Because he quotes Lord Langdale, who says he's never considered the mere retainer by a solicitor out of money, which sounds like what I would
No,
call
I
retention.
think it's very confusing, but he means retainer of the money, in fact.
Yeah.
What he says is, and we have been able to find no case in which mere retainer has been treated as payment.
That's, i.e. the solicitor helps himself to the money.
Yeah.
Yes. And then further down, he says about the cases where there is a settlement of account, but those are cases which there is a valid agreement which dispense with delivery of a bill accompanied by a settlement of account between the solicitor and the client. Then he goes on to refer to Whitcomb. And then he says, in this case, we find there was no settlement of accounts, but only a mere retainer by the solicitors. And we're of opinion that that is not in any sense payment. Now, the next case that I refer to, which I expect my lords and my lady will say is not on point, but again it refers to the settlement of account issue, is the case of Foss, Billsborough and Plaskett.
This is the one the judge relied on.
Apologies, I've missed Reed Thompson out. My own friend just indicated. I'm grateful to him.
Going back to Reed Thompson.
Yes.
Yeah.
So we can see this is a Queen's Bench Division case. Page 33 of the bundle, 34 of the electronic bundle. We can see the circumstances at the bottom. Second paragraph halfway down. The solicitor told his client that if she agreed to those terms, she would receive 150, would have to pay certain witnesses, and would not receive back a sum of 55.16 shillings, which she had paid him on account of costs. In February 1891, the defendant agreed to pay the damages in full and 120 for the solicitor's costs. The solicitor explained this agreement to his client and paid her 210. She then signed the following document. And then we can see the document that was signed, received from R.G. Thompson, the sum of 210, being the amount of damages received on my behalf from the defendants, and having regard to the fact that he has settled with them for a sum less than that to which he would have been entitled to cost if they had been unsuccessful, I hereby agree to allow the sum paid by me to him on account of costs as an equivalent for the abatement he has made to the defendants. So again, reference to a sum and an agreement.
We're going to look at Baron Pollock at page 465.
.465.
It says, I'm of opinion that transaction described amounted to payment. It was not a mere retainer by the solicitor out of money deposited with him. It was payment followed by the delivery of a bill of costs to which the payment could be referred.
And this refers to, and my learned friend refers to this in his skeleton argument, what would be payment between a solicitor and his customer is payment between a solicitor and his client. And I say that this can be distinguished because payment between a tradesman and his customer and solicitor and client, one would expect, although one is having to read into it, to some extent, but one would expect that there has been a trade carried out and then potentially an agreement for payment before, and then a confirmation as to what that is, and the client either agrees to it or disagrees. So that active involvement and agreement to a sum for a service, not just a generic agreement that I will build a wall and I'll charge you what I consider to be 25% of it after I've built it.
Okay, well, let's look at possible.
Neville J, page 41-42 of the bundle. Now the highlight I think does show actually on the bundle here. In my opinion, the solicitors have failed to establish payment. The company advanced sums from time to time to the solicitors on account of costs, which were credited to the company in the cash accounts in which they were debited with, amongst other items, the amount of the 3 bills of costs. This accounts shewing an ultimate balance of 17743 or thereabouts against the company. In my opinion, where clients have advanced monies on account of costs prior to the delivery of a bill, and the solicitors subsequently deliver a bill and appropriate the money of the clients in their hands in payment, this does not amount to a payment of the bill within the old Act. At all events where there has been no settlement of account. In my opinion, there was no such settlement in the present case. There was no payment here.
Well, there was no agreement there. There was no agreement to payment by deduction.
No.
So that's why that's the ratio of that case. The word settlement of account just simply means no agreement to deduction there. Yeah.
And then the reference to Harrison and Chew is this is not the one to which I refer. The one to which I refer is the one that should have been sent, that was omitted from the bundle.
You want the decision of this court?
Yeah.
Or Justice Dillon?
Yeah.
Lord Justice Nichols and Sir Fred Lawton.
Yes.
Names hundreds.
And this is the case to which Mr. Justice Bourne made reference.
Yes.
In terms of the explanation of what amounts to a settlement of account. So it's at 315, 316 of this additional copy.
Yeah.
And then the reference within Mr. Justice Bourne's judgment goes through the Roman numerals. So we can see here that reference to Mr. Harrison and Mr. Chew sitting down and preparing a statement in his presence, setting out how the money should be paid out.
Yeah.
It would be discussed, agreed, and written down. And then it goes on to say when those details had been agreed, it would be typed up together with the bill.
Does he say that this was a requirement, though? Anywhere? Seems that if you go back to page 313, having quoted section 70, subsection 4, he says the question on the appeal is whether, despite subsection 4, the court has inherent jurisdiction to direct taxation. So that's the issue before the court. And it seems to have been, the whole issue seems to have been argued on the basis that there had been payment.
Because of the settlement of accounts. Or because of what Bourne found to be an explanation as to what constituted a settlement of account.
Well, the holding is actually helpfully in the headnote. Held that the manner chosen by the parties to settle the solicitor's accounts, brackets as described in the enumerated paragraphs, was a payment within 74, and therefore, since the bills had been paid 12 months before the application for taxation, the subsection prohibited an order for taxation, but allowing the appeal, with Nichols LJ dissenting, that they had power to regulate misconduct.
So that was payment.
Yeah. It was payment, but it wasn't the only way to make payment.
It was payment referable to a settlement of account.
Well, of course,
On
because
these facts.
On these facts, yes, but it provides an example.
Yeah, it's just an example. That's really the point. That's
Yes.
put to you.
Yes.
There's nothing there that says that's what you need as a minimum in order to constitute settlement of account or payment.
No, it's an example. The next authority in the bundle is Carastas. Now, that refers to a statutory bill and what a statutory bill should indeed be, as Master of the Rolls.
you're now going to say, as I will well remember, but of course I remember absolutely nothing. I'm just looking at what I said. Which paragraph is it?
The paragraph highlighted is highlighted by my learned friend. It's page 74 of the bundle, page 75 of the e-bundle.
Oh, certainty is needed. Properly drawn bills ought to state the agreed charges. It's nothing to do with this, really. But
No, it's not. It's not a point taken. This has been a case that has been. It's not relevant in terms of if we were saying it's not a statute bill, we wouldn't be here having this argument.
I mean, I might comment it sounds very sensible advice.
No one's suggesting it isn't
No,
sensible,
no,
and no one's suggesting that
kind,
there might be
kind.
criticisms
That's very
in
kind.
terms of the bill in this case, but it's not relevant for the principles that
No.
need to be decided.
Good. And Potts?
Potts is a judgment that's referred to in my skeleton argument. It's Costs Judge Rowley. Reference at 82 of the bundle, 83 of the e-bundle. And Potts was very similar situation to the case before the court today. The highlighted paragraph there is at 32 of the judgment. Towards the end of that paragraph, reference is made if the client both authorises the payment and it's aware that it's happened, then payment for the bill can take place from monies held by the solicitor. If that authority or knowledge is not present, however, then it's not payment of a bill for the purposes of time limits. And then he goes on to refer to, LJ in Goff, which is the next case within the authorities bundle.
Right, well, can we just go back to what Costs Judge Rowley says at 32, which is where he's directing himself. He talks about the Victorian cases, then he talks about Goff, and then he says the essential point's not altered significantly. If the client both authorises the payment and is aware that it has actually happened, then payment for the bill could take place from monies held by the solicitor. So that's the proposition that he's then applying to the facts.
Yes.
Is that right or wrong?
I'm saying from that, the important element is that if the client authorises the payment, authorisation is important here, then payment can take place.
It's the second sentence that matters, though. He's not making some general statement that if not never. He's just saying if there's no authorisation, then there may not be payment.
Yes.
Obviously. No agreement, no payment. Now, I'm afraid to say it's coming up to 12:30. I think you were told that we have to rise at 12:30. Maybe you weren't, but you are being now.
We are now.
I'm afraid we have to rise at 12:30. We should be back at 2:05. Not 2 o'clock, I'm afraid. But I think we're running okay for time, are we not?
I think so.
Yes. Good. Okay. Then 2:05.
All rise if you're able.